Okay, good afternoon once again. We are still on law of contract. We have talked, the last time we met, we were looking at consideration. And we said that when we came to the rules or the essential elements of a valid consideration, one of them was that consideration must move from the promisee. We learned that when we say consideration must move from the promisee, it means that it is only a party to the contract that can provide the consideration, but not a third party. If you remember, I told you we'll be learning about a certain concept that is related to that. And that is what we are going to do this afternoon. This afternoon, we are going to look at privity of contract. That is what we'll be looking at this afternoon. Privity of contract. And let's look at this scenario. There is somebody called A. This A enters into a contract with another person called B for the benefit of another person called C. So it is like this. A enters into contract with B, and the contract that the A and B have entered into, C is the one that is going to benefit. That is what is here. Let's take it this way. The A is representing your father. B is representing a taxi driver. Then they see you. So C is child. So this is your father and this is you. So your father enters into a contract with a taxi driver and you are the one supposed to benefit. You are the beneficiary. Let me give you an example. When you were in JHS or even at the SHS level, some of you, the day students, your father may enter into a contract with a taxi driver to pick you every day, Monday to Friday, from home to school. And then your father pays a certain amount at the end of the month. So your father has entered into the contract with the taxi driver, but you are the beneficiary. So that's what we have done here. So your father enters into the contract with the taxi driver, then you are the one going to benefit. Now, let's look at what we can draw from this scenario. One, we are going to look at two questions. Number one, can C. So now we know that the C is the child, which is you. So can C acquire rights under the contract? Can C acquire rights under the contract? And what does that mean? In other words, if the taxi driver picks you and your father fails to pay the money, or the taxi driver, your father pays the money, let me put it that way, your father pays the money, but the taxi driver refuses to pick you, can you sue the taxi driver? That is what this one is talking about. Can you, the child, acquire rights under it? So if you can sue the taxi driver, if he fails to pick you, that means you have right under it. If you cannot, it means you do not have right under it. So that is question one. Question two. Can C, that is you, have duty imposed on him, or let's say or her, on him or her under the contract? Can C have duty imposed on him or her under the contract? Here it also means that if your father fails to pay them, and can the taxi driver sue you? That is what that one means. So the first one was to ask whether you can have any right under the contract. That means whether the taxi driver fails to pick you after your father had paid the money, you can sue the taxi driver to recover the money. Or Your father too, the taxi driver picks you at the end of the month, the taxi driver, your father fails to pay the money. Can the taxi driver sue you? To be able to answer these two questions, then you need to understand two things. The first one is what we have already done under consideration. The rule that said that consideration must move from the promisee. The second thing that you should also understand, and that will help you to understand this question, is when you understand the doctrine of privity of contract, which we are learning. We are learning about the doctrine of privity of contract. The privity of contract, that principle we call privity of contract. That doctrine we call privity of contract. If you understand it, then you know whether you can have right under the contract, whether you can sue the taxi driver, or whether there can be duty imposed on you, whether the taxi driver can sue you, should your father fail to perform his obligation under the contract. Now, so we know the first one, that consideration must move from the promisee. The question is, are you a promisee? I know you said no. Yes, you are not a promisee because you are not a party to the contract. So if you are not a party to the contract, then you cannot provide consideration. And therefore, if you cannot provide consideration, the taxi driver cannot sue you if your father fails to fulfill his obligation under the contract, because you are not a party to a contract. The contract is between your father and the taxi driver, not between the taxi driver and you. So you are only a beneficiary. Then if you are not that one, that means that you cannot also have any right under it. Then what is privity of contract? The doctrine of privity of contract states that it is only a party to a contract that can or that should provide consideration. That is what it states. It is only a party to the contract that should provide consideration. Are you a party to the contract? No. So are you the one to provide consideration? No. If the taxi driver wants to sue, is it you? No. Whom? Your father is the one that the taxi driver can sue. So it's between the two of them. So that is all that the doctrine of privity of contract is about. That if you are not a party to a contract, you cannot have any right under it, neither can you have any duty imposed on you. I hope you have understood that one. Now let's look at exceptions to the doctrine of privity of contract. You know, it is said that in every rule there are exceptions. In other words, even though we have learned that if you are not a party to a contract, you cannot enforce it. The doctrine of privity of contract says that it is only a party to a contract who can enforce the contract. Who can enforce the contract? It means if you are not a party to the contract, you cannot enforce it. But there are certain situations, there are certain circumstances that somebody who may not be a party to a contract can enforce it. And number one, in agency, what is agency? From law of contract, we'll be doing another law we call law of agency. And that's why certainly will be done when you come to school. We are going to finish with law of contract whilst you are at home. Then law of agency, when you come, that will be our first topic. So please take the lessons we are doing here seriously. We will not repeat them when you come to school. So that one, so let me now explain to you what is agency, so that you will know that in agency, even though somebody was not a party to a contract, the person can enforce it. Now let's look at it here. What is agency? Agency is a relationship between two parties, where one of the parties called principal. So I'm using P to represent the principal. Okay, principal. engages another person called agent to act on his behalf. So in agency, the principal gives the agent authority. You see, you understand the principle of delegation. You have that delegation. So if you understand the principle of delegation, then that is what is working here. The principal, but this is not, we don't call it delegation. It's a special type of contract. So the principal will give the agent authority to act on his behalf. When we go to agency, we shall have details of that one. What does that mean? You know, have you heard of estate agent before? What do they do? If you go to a place and you want a room, a house, or whatever to lease so that you pay rent, because you don't know the place, you can see an estate agent who will go and search for the kind of accommodation you want. 3-bedroom, a kitchen, and that and what. He knows that is his work. He's called estate agent. So you go and see, but then the person will go and search for what you want on your behalf. Then you pay the person commission. So you are called principal. The person is called an agent. So you have given the person authority to go and get an accommodation for you. And you have defined to the person what you want. 3 bedrooms, a kitchen, hall, this, that. So the person will get that specification for you. So the person is an agent. Then you are the principal. When the person has finished with everything, you pay the person. And the amount you give the person is called commission. So agents work for commission. But we are not going to spend too much time here. But I'm just give you the overview of it. Let's look at it. So the person that the agent will go to get the accommodation, the person was not a party to the contract between the agent and the principal. You see, for the agent to be able to go and get the accommodation for the principal, the two of them should enter into agreement. That agreement that the two of them entered into, that gave the agent authority to go and get the accommodation for the principal. That is what you call agency. So agency is a relationship between two parties where one of them, called the principal, grants or gives the other party, called the agent, authority to act on his behalf in respect of, number one, either disposition of goods. So the agent can be selling goods on your behalf, or either to render service, or whatever it may be. Maybe you specify it in the agency agreement. And in agency, you see, the person, the third party is here. So in this case, the agent will come here, get the accommodation. So it is the agent who will enter into a contract with this one. But you see, when the agent is entering into a contract with a third party called Mr. X, the agent is doing it on behalf of the principal. So it means that it is as if it's the principal who is doing it. In that case, if the agent pays money to the third party, and the third party fails to give the accommodation to the agent, the principal can sue the third party. You understand? But you see, why are we saying it is an exception? It's an exception because the principal, in essence, was not a party to this contract. But the law allows him to sue the third party. It is not the agent who will sue the third party because the agent acted on his behalf. We shall do more when we come to that. So that is why we say agency is an exception. Number 2, assignment. It's very simple. You have done this one, assignment. You remember when we were talking about sources of finance? You remember factoring, which is a source of finance. You remember we said that a company will buy debt. Yes, that is it. If the company comes, that factoring company, they come to you, they go to another company to buy their debt. Then the company from whom they bought the debt from will assign responsibility of collecting the money from the debtors. So when the company assigns that responsibility to you, you have the right. Even though you did not buy the goods, let's look at it. In the assignment, the company we have X, Y. This is the factoring company, Y. Then this is S, the company from whom they bought the debt. So, and the debtors were Mr. A, B, C. Mr. A was owing 5,000. Mr. B was owing 20,000. Mr. C was owing 15,000. So in all, the debt was, outstanding debt was this one 20,000 plus another 20,000, making 40,000. So when they came to buy Y, which is called factory company, came to buy the debt from X, then they paid, let's say, out of the 40,000, they paid, let's say, 25,000. So now if they're able to collect all the debt from ABC, then they will get a profit of 15,000. Now, because they have got the debt, S had assigned to them the right to go to these ones to take the A. So when Y comes to you, you not say, I did not buy the goods from you, I bought the goods from S. Now S has assigned that responsibility to them, so they can pick it from you. So that is for the assignment. The third one, very simple, straightforward, restrictive covenant on land. Restrictive covenant on land. And this restrictive covenant on land allows or which are imposed upon subsequent owners. Restrictive covenant on land which are imposed upon subsequent owners. Land law. Land. I'm not talking about land. I'm not talking about a landlord like this. Land, Lord. That's not the one I'm talking about. I'm talking about land law. Law that concern, or laws that concern land. We have land laws. The landlord is said that there is what they call restrictive. There's what they call restrictive covenant on the land, and that restrictive covenant is imposed upon subsequent owners. Now, I'm going to use some guests. They are here. I'll call them right now to do some. The two of you come. Pero, come. And then, what is the name? Prisla, the two of you should come right now. Please, we are using, the time is good, so hurry up. Now, assuming this is now come here. This is a piece of land. You to come, the three of you should come, stay here. This is a piece of land. This is a piece of land. Now I'm the owner. Come. I sold this land to this one. So now you see this what you are referring to as subsequent owner. So I was the owner, I have sold to this one. When I was selling the land to this one, I told this one that part of the land I have given to somebody to use. So somebody is using the land for something. So I told this one, the two of us entered into that agreement. And she accepted. So there is somebody who is using part of the land for something. She agreed. So we have. So there is a restriction. So that is the restrictive. What is that one? That is the restrictive covenant. So there is covenant between the two of us. And there is somebody who is also using part of the land for something else. And she had accepted it. Now, so I'm no more the owner of this land. She also sells this land to another person. So the next person should come. Sell the land to her. So she sells the land to this one. So she's no more the owner. Now the question is, that agreement between myself and then the first person to whom I sold it, does it affect this one? Yes. As the land moves from one person to another, so this one can not say that I wasn't the one that a jack entered into that contract. So me, the person whom Eja said was using the land, the first owner said was using the land, me, I will not allow the person. Once you abide the land, as the land is moving from one person to another, that restrictive covenant will move with it. So this one too will have to abide by that one. Then this one too sold the land to this one, Prisla. This is Poro, this is Prisla. They just wrote business management today. So look at their faces. So now Poro too has sold the land to Prisla. Now, does the restrictive covenant affect her? Yes, it affects her. It affects her. So she cannot only say that she wouldn't allow the person to do it because she was not the one who entered into that agreement with me. So in essence, that's why it is an exception. Even though the subsequent owners, now I have explained to you what is meant by subsequent owners, were not those who entered into that agreement with the first one. As the land moves from one person to another, that restriction moves with it. And they would have to abide by the original covenant or contract that was entered into, or that agreement between the owner and the first person to whom the land was sold to. Bye-bye. So that is the restrictive covenant. Now another one is third-party insurance. When you do insurance, you know that one too. In insurance, there is the type you call third party. When you buy a car, you have to go for third-party insurance. It is compulsory. Now, if your father has a car, ask your father to show you third-party insurance. If your mother has a car, it's compulsory. So they cannot say they don't have. Now, who is the third party? Your father has a car. Your father is the owner of the car. The insurance company, they are there to insure the car. So the insurance company is one of the parties. Then your father is also another party. Any other person is a third party. So if the car knocks down somebody, if the car destroys somebody's thing, then if they have gone for third-party insurance, then the insurance will pay that person. The insurance will compensate that person who was involved in accident. If you were on a car or in a car, and then the car was involved in an accident, if the car had been insured, the insurance company will be the one to compensate you. Now, why is it an exception? Why are you saying that it doesn't follow that rule of privity of contract? Very simple. You see, you were not the one who went to insurance company to buy the insurance policy, the third party. But once the accident has occurred, you can take legal action against the insurance company. All that you need to do is that when the accident occurs, the owner will have to go and see the police. They will come, do examination, whatever. They send a report to insurance company that the accident has occurred. You were so and so were those who were involved. Then you can claim the money from the insurance company. It is not the owner who would have to go and claim the money on your behalf. Even though you were not a party to a contract between the insurance company and then the owner, you will be the one to claim the money. So that is why it is also an exception. So these are exceptions to the doctrine of privity of contract. Now we are through with the doctrine of privity of contract. Now remember here, I talked about all these things. Then I said to answer these questions, the doctrine of privity of contract, and then the further consideration must move from promisee. Then I said it means privity of contract means only a promisee to a contract can enforce it. So if you are not a promisee to a contract, you cannot enforce it. And this case has already been done. Schwedel versus Atkinson. You remember William Tweddle and William Guy's case. So that is it, to support this one. So that is for that one. So we have finished with the doctrine of privity of contract. We will end it here and see whether you'll be able to answer the question. Define the doctrine of privity of contract. Give 4 exceptions to the doctrine of privity of contract. Now let me give you a scenario too. X entered into a contract with Y to supply him with raw materials. X paid the money, but Y has refused to supply the raw materials. Z, who is the son of X, wants to take legal action against Y. Advise C. Till we meet again another time. It's bye-bye.